Mogesalmebit, it's our official language, Georgian, but everybody knows that it will be in English conducted, and our sessions are also in English. And so, generally, yes, our students, they know that English is important, not even obligatory for master level in university, in our university. And welcome everybody. Thank you very much for coming here, but it's also a great privilege for us, for the university, and for you also, to have this public lecture, and we have such a distinguished guest, Judge Corner, if pronunciation is correct. It's our first meeting, but time by time we'll improve. And she's really, I mean, not just because, first of all, of course, she's judge of International Court of Justice and with a very knowledgeable and competencies, but also she has very important legal background, working in different areas, but primarily in criminal law in England, UK, or whatever, England, in Wales, as a judge. And besides, as a prosecutor and judge for different international cases from Yugoslavia and other cases, and very experienced. And her not just theoretical but practical knowledge is very important for us to share. And the university is trying to expanding our knowledge just to not to be focused on Georgian legislation, but on international law. So today's public lecture will be important not just for our students, but for other professionals and students from other universities and for other professionals. Besides, we have a series of lectures for 3 days, short-term but very intensive lectures. And I would like to thank also our distinguished guest lecturers. Mr. Jeremy McBride just arrived today, and from tomorrow he will start teaching, also from UK. But we know him for a long time, even we met first maybe many years ago in Batumi, as I remember, in the Constitutional Court visiting. And now he works in many areas, including advising Georgian government and other institutions on international legal issues, and working with Strasbourg Court with different players. Also, we will have online a judge from Ukraine, Mr. Gnatovsky. It's also a privilege because he is also very busy, but he was very much committed to participate at least online. But for the future, we hope that he will join us in live. And also another British scholar, important, but also practitioner, Wayne Jordash, yes, okay. British accent is a bit, I have more American influence maybe, or Georgian, but Jordash. He will join us also online, where also he's very active, representing different clients before international courts. And of course, we have also very local, very experienced for the Georgian level professors. Tina Goletiani is in the heart of this. Our professor, she's here. Also, Tamna Tomashvili. Also, she will join us soon. And Levan Meschoradze was today. He was a former visiting professor, but he's former agent of Georgia to the Strasbourg Court. And also very interesting moderators, of course, and I think that we'll have very intensive, very good occasions to share experience international human rights law, international criminal law, international law generally. And of course, I would like to thank our partners. And Mr. Shkolnikov represents here, and he will speak himself, UN. But there are so many organizations, not to be mistaken about the name, you will explain better your organization specific. And of course, Open Society Georgia Foundation, Georgi Chitidze is somewhere, he's also our visiting professor and moderator. And also I would like to pass the floor to Georgi Gwalia, our vice rector, a great supporter and general director, and they very much support our initiatives in all areas, including this one, and they will be very much eager also in the future to have such a joint initiative with our partners as with international, prominent international experts. Please.
Thank you. It's a great pleasure and honor to host our honorable guest, dear Judge Corner. Mr. Shkolnikov. It's really honor and privilege for me to participate in this opening part of this very important and fascinating lecture series, which is conducted with the organization of our law school. Ilia State University somehow provides and supports the field of the discipline of the law, not only at the academic level, but at the same time facilitating and supporting the public activities like this, with the aim to somehow contribute to important challenges that our society or the global society might be facing. When I looked at the program of the lecture series, it's amazing, the speakers are amazing, and I believe that in the current era of the world, we are in the context of the current world politics is very much at the stage when it's really very important that the international law and the international institutions like UN should be playing much more important and active role in regulating the conflicts and the interstate relations, and not only, of course. And I have great optimism about the efficiency of international law and efficiency of rules-based and norms-based international order, that at some point in the future we will ensure that peace and security are achieved through the principle of that all states and the major states are somehow guiding their international behavior on the basis of the established principles of international law. So with this, I would like to welcome also our students. For them, this is really amazing experience, and I wish you really successful and productive lecture today, and also the lecture series, which will last for 3 days. Thank you very much.
Thank you very much, Mr. Vice Director Dean Popashvili. It's always great to be here. It's not the first time that United Nations Human Rights Office, which I represent, supports activities with Ilia State University. We're very pleased to have this, which is a 3-day series on 3-day lecture cycle on international law, on 3 branches of international law: international humanitarian law, international criminal law, and international human rights law. We're, as everybody here, I would say that we are very pleased that you, Judge Corner, and many distinguished lecturers have been able to join us, be it online or in person. Our office engages quite a lot with universities here, with regional universities, because we believe that you are the future of human rights here in Georgia and internationally, and we would like to see the next generation of human rights defenders to grow up here, to take human rights even to the next level, to address current challenges that the world is unfortunately not stopping to face. I also would like to just say that we are particularly pleased that this is taking place at this time, because this is the 25th anniversary of the Rome Statute, 70th anniversary of the European Convention on Human Rights, but also 75th anniversary of the Universal Human Rights Declaration is not so far either. So I hope that those of you who are here only for an hour and a half will really have something that you have to think about after this lecture, but those who are doing this entire three-day cycle will definitely carry with you some new information, some knowledge, and things that maybe will continue sparking your interest in human rights. So thank you for joining us, and if I'm not mistaken, Judge, you have the floor.
Right, if you don't mind, I need to stand up. Yes. Please. I will introduce once again.
Sorry, Tina.
moderate the questions.
Yes, so no, I will take the opportunity once again to echo what was noted, and I'm extremely pleased to host Her Honor Judge Joan Kona at the Ilia State University. Professor Paposhvili gave a background, but I also would like to, I think for the students and for the audience, it is extremely important to note and underscore once again that before us today is really a international renowned expert and professor of international and criminal law. Her Honor has been practicing law for over 45 years, nationally and internationally. She has been prior to her being appointed as the or assuming obligations at the International Criminal Court. She has been a senior prosecutor at the International Criminal Tribunal for former Yugoslavia, and it was 2009, 2012. And between 2004 and 2005, she was senior legal advisor to the chief prosecutor of Bosnia and Herzegovina during the establishment of the war crime section in the country's state prosecution office. And at the same time, she is one of the Judge Kona is one of the leaders in organizing and teaching law among and disseminating the knowledge among lawyers and students. So without further ado, it's a pleasure to listen to you, to learn from you, and maybe if the audience have questions later, I will try to moderate.
First of all, may I say what a pleasure. Can everybody hear me without the microphone? Shall I use the microphone? Because is it on? Yeah. It's a real pleasure to be back here in Georgia. I was actually here for the first time 2 weeks ago or thereabouts at another university with other judges from the International Criminal Court. But I didn't have a chance to see much, so I'm delighted to be back here again. The reason I'm standing is I spent many more years as a barrister in United Kingdom, in England and Wales, and then at ICTY before I became a judge. So I find it easier to stand rather than sit when I'm talking. So the title that I was given could actually, if I wanted to, make the lecture last a very long time, on the basis that reflecting on the past and present and envisioning the future of global justice. Well, that could take days, but what I'm going to do is try and encapsulate, in I hope about 45 minutes or so, and then take any questions you may have, the past, the present, and hopefully be a prophet about the future to a certain extent. I suppose you could say that modern international criminal law really began at Nuremberg. And although when I teach about the history of international criminal law, I say it actually began in 1352, when there was a trial that involved a number of different municipalities or states. There's no doubt really that Nuremberg was the beginning, followed very shortly afterwards by the Tokyo Tribunal, or to give it its proper title, the International Tribunal for the Military Tribunal for the Far East. When I was starting as a young lawyer, I was given some very good advice by a more senior lawyer in whose office I was, who said, go back and read the speeches of great orators, starting, they said, with Aristotle and working your way through until the modern age. Well, I am not going to start today with Aristotle, but I do think that everyone should read and reread the opening remarks by Robert Jackson at Nuremberg, and indeed often forgotten, but the opening remarks of the prosecutor, a man named Joseph B. Keenan, who most people won't remember the name of, at Tokyo. Because what Jackson said was this, and those words I think have shaped international criminal law. The common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. When I say that we do not ask for convictions unless we prove crime, I do not mean mere technical or incidental transgression of international conventions. We charge guilt on planned and intended conduct that involves moral as well as legal wrong. Judicial action always comes after the event. Wars are started only on the theory and in the confidence that they can be won. Personal punishment, to be suffered only in the event that a war is lost, will probably not be a sufficient deterrent to prevent a war where the war makers feel that the chances of defeat are negligible. But the ultimate step in avoiding periodic wars, which are inevitable in a system of international lawlessness, is to make statesmen responsible to law. And I shall be continuing this theme in my discussion tomorrow on head of state immunity. Finally, on the quotes from him, he said this: "The usefulness of this effort to do justice is not to be measured by considering the law or your judgment in isolation. This trial is part of the great effort to make the peace more secure. One step in this direction is the United Nations organization, which may take joint political action to prevent war if possible, and joint military action to ensure that any nation which starts a war will lose it." Well, you may think that history has not shown that he was a great prophet on that. Joseph Keenan, when he was opening the war crimes trials in Tokyo on May the 3rd, 1946, so roughly about 9 months after the Nuremberg trial started, he said this: "No one needs even a slight reminder that wars in our time are quite different to those of old. Today, and far more importantly tomorrow and forever, wars can be nothing other than total wars. All wars have no limit of space or territory. Victims will be the young and the old, the armed and the unarmed, and hardly a home from one in a great metropolis to that in the smallest village will be free from destruction." You may have thought, or you may think, that Mr. Keenan was perhaps a better prophet, particularly in the light of the events of the last few days in Israel and Palestine. So, those were the two tribunals that began modern international criminal law, and in fact really gave a name. I don't think that international criminal law as such existed. Of course, the conventions, the Hague Conventions and the later Geneva Conventions were in existence, but as a body, that was the beginning. And there things, as we know, rested for a number of years until 1993. And what brought about the creation of then really a spate of differing tribunals was, of course, the events in the countries of the former Yugoslavia, and in particular in Bosnia. The television crews that went to the camp in Amasca and the camp in Ternopily brought back images in a modern time that nobody thought could happen, of the men skeletally thin behind barbed wire. In fact, in not the worst camp by any stretch of the imagination. Ternopily was, as it were, more of a transit camp than Amasca and Keratam had been. But what the journalists saw there were the people who had been moved there from other camps. And that and the investigations that were carried out by the so-called Commission of Experts with refugees from Bosnia incited the United Nations Security Council, for once acting as a body, to set up the International Criminal Tribunal for the former Yugoslavia in 1993. The fact that a tribunal had been set up in 1993 to deal with those events did not, unfortunately, as indeed no tribunal really has, deter the next big conflict, that in Rwanda in 1994, which was literally the genocidal actions against the Tutsis in Rwanda. And having started, the UN Security Council continued and set up the International Criminal Tribunal for Rwanda, both tribunals being known by their initials, ICTY or ICTY, for some reason, as the Brits kept saying, but ICTR for Rwanda. That really was the beginning. In fact, there were no other, they were the only genuine ad hoc, so-called ad hoc tribunals, because they were entirely staffed by internationals, both as judges, prosecutors, and defense to a certain extent, and the same with ICTR. The tribunals that followed fairly quickly after that were rather more hybrid tribunals. The next one was that of East Timor in 2000. Nobody ever remembers about East Timor, about what happened there, the violence. It didn't last a very long time, and altogether, if one looks at the results achieved, it wasn't particularly successful. Sierra Leone in 2002. Cambodia was set up in 2004 to try those who were allegedly responsible for what took place in the 1970s. Very few people were tried. Most of them were very old, and the trial took a very long time. It is still actually in existence, although it's obviously closing down. Then the Tribunal for the Lebanon, the STL, set up to deal with the alleged assassins of the president, Hariri, and of Lebanon. It was, in fact, really a tribunal operating under Lebanese law, but with an international component. And finally, and that's only recently closed its doors, sorry about this. Before I come to the ICC, just to show that the coming of the ICC 20-odd years ago, 25 years since the statute was promulgated, hasn't stopped the setting up of hybrid or specialist tribunals. The Kosovo Specialist Chambers set up in 2015. Again, a hybrid court. It's been established under Kosovo law, but has its seat in The Hague, and is to deal with the alleged crimes committed by the then members of the Kosovo Liberation Army, who then became the government. And so the main accused on trial is Thatcher, who at the time of the warrant was issued for his arrest, was still the president of Kosovo. So you have all those tribunals. And then, of course, in 1998, the Rome Statute, and in 2002, the beginnings of the ICC. As you've been told, I worked for ICTY not as a judge, but as a prosecutor. I worked on two separate occasions, firstly between 1999 and 2004, and then again between 2008 and 2012. I'm glad to see that this lecture is grabbing the attention. I'll just wait. I always had an effect, I'm afraid. It's when I said it was going to take 45 minutes that obviously this drove everybody off. Right, ICTY. Probably, in many ways, the most successful, if one looks at the statistics which it has on its website, of all the tribunals. 161 people were indicted. They were indicted for the crimes which are now standard for the tribunals. That is to say, genocide, crimes against humanity, and war crimes, as a general description. Obviously, grave breaches of the Geneva Conventions. These statistics actually do make quite interesting reading. If you look at it at one back, there were 161 indicted. 90 of those were convicted and sentenced. Some 19 were acquitted. 37, in some 37 cases, proceedings were withdrawn, particularly at the early days when the indictments were issued against very low-level perpetrators, and as the level of the accused rose, so it was decided that these cases would be discontinued and eventually tried, as it turned out, domestically. And 13 of the cases were transferred to be tried by courts in either Serbia, Croatia, or Bosnia. But some idea of the magnitude of this endeavour can be given by the other statistics. There were more than 4,500 witnesses testifying in over the 20-odd years that it ran. 10,800 trial dates, and 2.5 million pages of transcript, which explains why, if anybody wants to look anything up on the ICTY website, or the it's now called the IMRCT, it is almost impossible to find. Their search engine is not good enough to cope with that amount of material. ICTR, somewhat less. They indicted 93 individuals. They had 61 convictions, 14 acquittals. They withdrew some indictments, and some individuals died. In fact, the last the very, very last trial, almost certainly to be held under the ICTR, ICTY residual mechanism, has just concluded in The Hague. Kabuga, who was the last effectively missing indictee from ICTR, the trial was stopped because he is exceedingly old, and the psychiatrist said that he simply was unable to follow the proceedings. Interestingly enough, for those of you who are interested in whether these trials, which take place so long after the events with accused who are so old can take place, the argument was made by the prosecution that the trial should continue without his participation, and the judges should come to a conclusion that he had done the acts, but without deciding whether he had the mental element, the mens rea, to go with it. That was very much drawn from the English and indeed Scottish procedure, but it didn't find favour with the appeals chamber, and so the trial has been stopped. The only question is what's going to happen to him. What were the successes? I suppose first and foremost, the creation of the jurisprudence in respect of international crimes. At the time when I went there, 1999, there'd been, I think, 2 or 3 trials. There was almost no jurisprudence. Nobody had any idea what was going to fly, as it were. What were the elements that were required? What was the evidence required to prove the elements? Was there a difference between deportation and forcible transfer? What was required in genocide? And as you know, the one conviction for genocide, there were convictions, but the one incident which was found to be genocide was the killing of 7,000 men and boys in Srebrenica. The prosecution, and I was one of them, one of the trials I did was Bergenin, who was the political leader of northwest Bosnia, and together with a general called Talic, who died before the trial was concluded, we charged them with genocide in respect of the events of 1992, as happened in the cases of Karadzic, Milosevic, and the like. We did not succeed. I'm not surprised we didn't succeed, because I think it was arguable that what was happening was not the destruction in 1992 of, in whole or in part, of the Bosniaks or the Croats. What they were trying to, what the Bosnian Serbs were trying to do, and these were all cases against the Bosnian Serbs, was drive them out of the areas they believed to be Bosnian Serb. However, in the case of Srebrenica, as you know, anybody, both Karadzic and various other military leaders were convicted of genocide. And in the case of the ICJ case of Bosnia against Serbia, in which I also took part, it is my only claim to fame, normally as a criminal barrister, that I'm one of the few who took part in a case in the International Court of Justice. And there they upheld the view that what took place in Srebrenica was genocide. So, jurisprudence. There were both convictions and acquittals. And that is important because all too often international criminal courts generally are either accused of being victor's justice, as they were at ICTY, or courts that are all too ready to convict. Acquittals are important because they show a balanced and fair view being taken. It produced experienced investigators, and lawyers. The international criminal law world is a small one, and you fall over the same lawyers wherever you go. And indeed, it so happens that the case that I'm trying at the moment at the ICC, which is the case of Al-Rahman, who to do with Sudan in 2003 to 4, the person prosecuting is someone with whom I worked at ICTY, which I obviously disclosed to all the parties and said it would make no difference to any rulings which I made, and the defence and the representative victims all agreed with that. But it did create this body of experience, and investigations into international crimes are exceedingly complicated and difficult, as everyone knows. When the investigators first went down to Sarajevo in 1994, the siege of Sarajevo was still continuing. It was almost impossible to get into other areas. And the same happens with all conflicts that are now investigated where they are ongoing. For example, any investigation that is to go on into what is happening in Sudan at the moment is impossible because nobody can get in or out again. Witness protection measures. These all developed as a result of ICTY and ICTR. Obviously, technical developments helped. Measures that were not available in Nuremberg, such as voice distortion, face distortion, and the like, all developed through the tribunals. The international support for both tribunals was very great, and in some way woke up, I suppose, international countries to the necessity for some kind of international criminal justice. The budget, of course, was massive, absolutely massive. At its height, when it was prosecuting leaders all over the place, 2010 to 2011, the budget of ICTY was over $286 million, which is a lot of money. And its other successes were the fact that its accused were in fact surrendered in some form or other to the court. It took a long time. The prosecutor under whom I worked, Carla Del Ponte, had an unerring knack of getting leaders to hand over accused, or to make sure they were handed over. She would simply go to the office, bang the table, and refuse to move until agreement was reached. And finally, on a major, as it were, aspect of the crimes, crimes of sexual violence, which we hear so much about these days. At ICTR, 52 of the 93 accused were charged with rape or other crimes of sexual violence. And in a case called Akaesu, the trial chamber not only defined the elements of rape and said, of course, that the circumstances in which the rapes took place are in themselves coercive, and it does not require, therefore, there have been individual consent, and held that it can form, and this was extremely important, an integral part of the process of destroying a group. What they said was this: these rapes resulted in physical and psychological destruction of Tutsi women, their families and their communities. Sexual violence was an integral part of the process of destruction, specifically targeting Tutsi women and specifically contributing to their destruction and the destruction of the Tutsi group as a whole. In ICTY, more than 70 individuals were charged with crimes of sexual violence, including sexual assault and rape. In fact, in the very first case of Tadic, one of the more horrific incidents described at the Amasca camp was that one of the detainees was forced to, by some of the uniformed guards, including Tadic, to bite off the testicles of another detainee, and he was convicted of sexual assault. There were other trials which were almost wholly concerned with sexual violence, in particular the ones in Focha, Kunarats and others, and where there was the first conviction as a crime against humanity, rape as a crime against humanity, and in fact as rape in conjunction with sexual slavery. Women were kept in houses in Focha to act as I say, sexual slaves. And so those are, in a summary, the effect of ICTY and ICTR. The criticisms, first of all, as far as ICTY was concerned, was that they were held out of the country. And therefore people couldn't go to the court and see what was happening and were dependent on television broadcasts. In fact, one of the major advances was that a company called Sense actually put out regular programs and had regular viewings of the various trials sent to the territories of the former Yugoslavia. And in the ICTR trials, they were held in Tanzania rather than Rwanda. The difficulty was, at the time, the rule of law in both places had really broken down, and it wasn't possible to hold those trials. Then the expense, the length of time that the tribunals went on for, length of trials, some of the criticisms were misguided. Milosevic, was always said that had Milosevic's trial not taken 6 years, he might not have died and there would have been a verdict. However, one of the many reasons why the trial took so long was the fact that he was not well, and there were great periods when the court could not sit. If I take my trial that I'm doing at the moment, the prosecution case began in February of last year. Began in April of last year, and on the face of it concluded in February of this year, the prosecution case. However, in fact, we only sat some 80 days out of those, 10 months or so, because we had to compete with other trials. There aren't enough courtrooms. But nonetheless, the length of trials undoubtedly are a matter that needs to be considered, and indeed at the ICC is being considered. The procedural elements of the trials, a great deal of variation between trial chambers. The same criticism has been levied at the ICC because of the fact that in one court you may have documents admitted by strict proof of the provenance of the documents. In another case, they just all go in under what's called the submission system. I should say straight away that steps have already been taken to ensure that the procedure is the same for each trial chamber. Plea bargains, a very American thing, but a very, very useful tool if properly explained. And no one explained really the importance of a plea bargain, what it actually meant, and why it was useful for the progress of international criminal justice. On the same sort of topic, inconsistent sentences. There was no rhyme or reason. It depended very much on the judges what sort of sentence was passed. And to take but one example, Starkich, which is another trial that I did, who was the mayor of an area called Priador, or a town called Priador, when he was sentenced, originally received a sentence of life imprisonment from the three judges. That was overturned on appeal, and he received 40 years. Now, he was an important figure, but nothing like as important as Karadzic. And Karadzic originally received 40 years from the trial chamber, which was overturned and turned into life imprisonment. But none of that helps. And one of the many things that is still missing from every jurisdiction is a proper sentencing policy. So the legacy of ICTR and ICTY, firstly, as I say, the jurisprudence, the factual findings, how these were arrived at, and the judgments and the decisions contributing to substantive and procedural international humanitarian law. And also, of course, it was the forerunner of all courts up and to including ICC. Interestingly enough, when the Rome Statute was promulgated, and the article which was 21, which references the applicable law to be applied in the tribunals, that does not mention any of the jurisprudence from ICTY or ICTR. It's fair to say, at that stage, very few trials had taken place at either of those two tribunals, and although it's not mentioned, before a body, the ICC developed its own body of law, that in itself, those decisions in fact were relied on. And that of course brings me to the ICC. The first countries to sign, interestingly enough, was Senegal in February 1999, followed by Trinidad and Tobago in April. The first European country to sign was Italy in July of 1999. And of course, it needs no repetition that of the major countries that have not signed, they are the USA, Russia, China, and Israel. And of course, there are many others, such as Sudan. There are a number of differing views of the ICC, and no doubt in the question and answer session you will tell me what your views are. The pessimistic view, as I put it, was expressed by a gentleman named Mr. Rademacher in 1999, I think it was. He said, reform has become a watchword at the court and amongst its supporters, but the reforms under consideration are all akin to recommendations for improving the propulsion system of the Hindenburg. If adopted, it is possible they will improve the day-to-day operations, but they do not begin to address the fundamental design flaws that are conducting the institution towards spectacular failure. He didn't mince his words, this gentleman. The Washington Post, also, it was 2021. The Washington Post was slightly more optimistic. They said, let there be no misunderstanding. The court is here to stay. The ICC is the realization of a long-standing call for justice. It embodies the sentiment that world leaders have expressed time and again in reaction to atrocities. Never again. The ICC is the only institution that can deliver justice to the victims of the most serious crimes when all other venues fail. This makes it indispensable in the global fight against impunity. And this from the Washington Post. And finally, perhaps the most realistic was expressed by Elizabeth Wilmhurst, who was the Foreign Office person who dealt with very much the setting up of the ICC, was present at the Rome Conference, and who was present at a Chatham House meeting in June of 2019, which is what prompted all these posts, really. And she said, there is now a perception in many quarters that the ICC has not fulfilled the expectations of its founders. The court's proceedings are cumbersome and lengthy. Many of the accused are still at large, including Omar al-Bashir, the former president of Sudan. Some 1.5 billion euros have been spent, and there have been only 3 convictions for the core international crimes. And I suppose that does express what many people do feel about the ICC. Particularly if one looks at the statistics of ICTR and ICTY over roughly the same period of time. But there is, of course, a major difference, which none of the commentators really take into account properly. And that is that the preamble to the Rome Statute said in terms this: emphasizing that the International Criminal Court established under this statute shall be complementary to national criminal jurisdiction. So it is not the ICTY in particular took precedence over all the cases of war crimes that were under investigation. In fact, the very first case came from Germany. Tadic had been arrested in Germany. Many of the cases that were started or investigated within Bosnia or Croatia or Serbia itself under the Rome Agreement called the Rules of the Road, all cases had to be sent up to ICTY for assessment. So that was the major difference between the earlier ad hoc tribunals and the ICC. And of course, Article 17 says that the court shall determine that, of the ICC statute, that a case is inadmissible where A, the case is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. B, the case has been investigated by a state which has jurisdiction over it and has decided not to prosecute unless the decision resulted from unwillingness or inability of the state generally to prosecute. So the two things are, state has a go at prosecuting it first, or there's a proper decision has been taken not to prosecute. So that is the major difference, and plus, of course, if the person concerned has already been tried, the well-known principle of ne bis in idem. Right, so the next problem that the court faces is the number of places, situations as it's called, that it has to investigate if it's referred to it, whether it's by the prosecutor or the state or the Security Council or whoever. At present time, there's investigations going on into Afghanistan, limited now to the role of the Taliban and not the United States troops for reasons that many may think were political, and who am I to comment on that? Bangladesh, the Myanmar crisis, Burundi. There are two separate investigations into events in the Central African Republic, the Côte d'Ivoire, the Democratic Republic of Congo, Darfur, Georgia, Kenya, Libya, Mali, Palestine. This is the Palestinians bringing the case against, or attempting to bring the case against Israel, the Philippines, Uganda, Venezuela. Colombia, the investigation into that ran for 17 years before it was closed last year. And there are still preliminary examinations going on. In other words, before a situation or investigation has been even opened. In Guinea, Nigeria, the activities of the Boko Haram, obviously Ukraine, both Ukraine in 2014 and Ukraine itself has been opened, and two involving Venezuela. Obviously the crimes are the same, and I'll deal separately, briefly, with aggression. But genocide, crimes against humanity, war crimes, jurisdiction arising if they took place on the territory of a state party, if they were committed by a national of a state party, or if the crimes were referred to the prosecutor by the UN Security Council. That has only happened twice, the first being in respect of Libya, and the second in respect of Sudan, 2003. The crime of aggression, which is obviously, if I can put it that way, flavour of the month at the moment. It's a very English idiom. But I think it's important to remind ourselves of how it's defined in the statute, Article 8 bis. It's the planning, preparation, initiation, or execution by a person in a position effectively, and I emphasize the following words, to exercise control over or to direct the political or military action of a state. And then it defines the act of aggression, which is obviously armed force by a state against a sovereign territorial integrity or political independence. And then, of course, as we all know, Article 15 says that the court can only exercise jurisdiction in respect of that crime, firstly, if it was passed by a number of states, which it has, but in respect of a state that is not a party to the statute, the court shall not exercise its jurisdiction over the crime of aggression when committed by that state's nationals or on its territory. The point that, that being the point why the ICC has no jurisdiction, the Ukraine it does, of course, have in its criminal code under Article 437 planning, preparation and waging of an aggressive war. Planning, preparation or waging of an aggressive war or armed conflict or conspiring for any such purpose shall be punishment by imprisonment. Quite a low sentence of imprisonment, but it doesn't in any way say that the people who are charged with it have to be those, as I say, under the statute, who, sorry, just find the words again. Exercise, control, or direct political or military. It doesn't have that caveat. So, in theory, and this is part of the ongoing discussion about what is to happen, anybody, the lowest soldier, could be prosecuted for the crime of aggression. Can I just say straight away, I cannot, however, if you go to asking questions, I clearly cannot discuss in any shape or form anything to do with the crime of aggression in Ukraine or the ICC or anything about whether I think that the prospective tribunal that may or may not be set up to try the crime of aggression is a good or a bad thing. So don't ask me any questions about that. What's the most interesting thing that the ICC did, really and truthfully? It's, of course, the first standing court. And one of the interesting aspects is that whenever something does break out, whenever there's a conflict going on, the first thing that is said is refer it to the ICC. And second, victim participation. Standard here in Georgia and in all civil law countries, but did not exist in any of the earlier tribunals. Therefore, because we don't have it in English trials, largely because we have juries, and we don't have judges deciding on the verdict. I therefore had no experience of victim participation at all until I started my present trial. But I am utterly convinced that it is a good thing, to put it in simple terms, and that it works. It's taken a long time to try and find the required balance. In the beginning, there was a lot of, the Lubanga case really set the boundaries, but there were a lot of problems about what rights representatives of the victims had. They're not the same rights that a victim would have in a domestic trial, for example, here in Georgia. They're much more limited as to the questioning they can ask, the questions they can ask, and also any interventions in the legal or procedural elements. The problems of the ICC, first of all, I told you what the funding for STY was. The ICC's funding, given the number of situations it has under investigation, is really and truthfully insufficient. But not surprisingly, the states parties who provide the funding are not anxious to increase the budget in times of economic crisis. In the aftermath of COVID, no state wants to be seen to hand over a lot of money to an international court that people say isn't achieving a great deal. It depends what your definition of achievement is, but if nothing else, it is there and operating. It has really, realistically, too many open investigations. But there's nothing that can be done about that because matters keep being referred, and there is an obligation under the statute to investigate, and indeed those who refer it have a right to know that it's being investigated. But there simply is insufficient funding and personnel to deal with everything that's happening. One of the many questions I get asked is, well, why isn't Syria there? Well, if Syria were ever to be referred in any form or another, which is not likely to be, it would sink the place, because it is one of the most complex, obviously, conflicts that has taken place in recent times. Then you have the lack of cooperation in investigations. In Kenya, the trial chambers stopped the trial eventually because the evidence simply wasn't there, but didn't, in fact, enter verdicts of not guilty, because they said that there was a strong suspicion that witnesses had been bought off or terrorized. And so the Kenya case, although Ruto and Sang and all the rest of it are all continuing their daily lives, is still, in theory, an open case. Darfur, as I'll be saying for those of you who are going to be here tomorrow, the Bashir case has caused more problems than any other case as regards immunities. But that is still a case where neither Bashir nor his ministers, Haroun and Hussein, have been surrendered to the court. There's been no cooperation whatsoever, not surprisingly, from Sudan. And in Myanmar, the trial is limited to deportation, or the investigation, because Myanmar is not a signatory, and by what some commentators described as stretching the boundaries, it's only what took place on Bangladesh, which is a state party, that an investigation was able to be opened. But clearly, nobody can get into Myanmar to conduct investigations. The inability to arrest those for whom warrants have been issued. The ICTY had the assistance of the UN forces, or as they became known, the Stabilization Force, and also international investigators. And arrests were being made, and indeed, as I say at the end, indictees were being handed over. That is just not happening with those who are indicted is not the right word, because we don't use the word indictment. Those for whom an arrest warrant has been issued by the ICC. And inconsistent jurisprudence. That regrettably has been a feature of the ICC judgments. I was going to give some examples, but I see I've been going for nearly the 45 minutes I said I was. But the Bemba case, the standard of review on appeal. One of the matters, though, which has been of huge benefit to the institution as a whole, is the report that was produced in September 20 by the independent experts who made a number of recommendations which all parts of the court took very seriously. And one of them was particularly to do with, firstly, trying to follow appeals decisions that had already been made, was an important matter. So when I very quickly deal with the future, universal jurisdiction has obviously taken up much of the slack that the ICC cannot accommodate. And quite remarkable that in 2019, a civil society organization based in the United Kingdom, which is called the Burmese Rohingya organization, filed a criminal complaint before an Argentinian court against senior Myanmar officials alleging their involvement in crimes against humanity. And to file such a case in Argentina, even where none of the suspects and victims were Argentinian, but because Argentina incorporated the principle of universal jurisdiction. There are many other cases that are pending and have taken place over the last few years by countries who have adopted those principles. I regret to say that the UK is one of the worst. It's hardly prosecuted anybody for international crimes. An attempt was made to extradite Rwandans back to Rwanda who were alleged to have committed genocide and the like, and the UK declined to do it on the basis that the magistrate, and indeed upheld by the divisional court, decided that the difficulty would be a fair trial. But Spain very recently dealt with the prosecution of the officials in El Salvador who were responsible for the murder of 6 Jesuit priests in 1989. Germany has been particularly active. Very recently, in June of this year, the Regional Court of Koblenz convicted a woman of aiding and abetting genocide in respect of a Yazidi woman who was being held as a slave by her and her husband, was being raped and forced to do labor. I had this discussion, funny enough, with German judges when I was here last, because the sentence was somewhat odd. For if you're convicting somebody of aiding and abetting genocide, a sentence of 4.5 years does not seem to meet the justice. As I say, sentencing policy at the moment is still very much it depends on the country in which you're tried, let alone in an international court. So that in itself, of course, does have challenges. Firstly, we're still, I keep coming back to it, but we're still arguing about whether immunity applies to high-level officials. There's been criticism that a lot of these cases that are brought before magistrates involve the advancing of political agendas, the attempt to get a Spanish court to issue warrants of arrest for American State Department officials and so on and so forth. So, what does the future hold? Well, what it certainly holds is a lot more cybercrime. Those of you who may or may not have seen the press announcement that was put out, I think today, will have known that the ICC was the victim of a massive hack, so that all of us, for the time being, firstly, we've no idea what details are out there, who did the hack, and the result is that we can't use the internet in the office, which is deeply irritating, apart from anything else. The importance of open source evidence cannot be overestimated. The Syrian conflict was probably the first to be documented heavily by means of videos being uploaded onto the internet. Videos that sometimes it is impossible to work out who uploaded them, the metadata is missing, and hovering not in the background anymore, but very much in the foreground, is, of course, the ability to create deep fakes. I noticed that apparently in the elections in the Slovak Republic, which are about to take place, a completely false recording had been made of one of the candidates, which suggested that they would interfere in the election. And above all, there has got to be an improvement in cooperation and international relations. The court has outstanding at the moment, I'm not sure how many arrest warrants. I've already mentioned the three obvious ones, which are Bashir, Haroon Hussein, and unless people get their act together, then the purpose of the ICC, which is to hold trials of those alleged, and I emphasize alleged, it's often said they are the most responsible, but this is the allegation. Unless that happens, then we can all pack up and go home. So that is my rather depressing prediction for the future. Thank you all very much for listening.
Thank you very, very much for extremely informative and fascinating overview of, on one hand, the development of international criminal justice architecture, and on the other hand, your vision and very comprehensive overview of achievements and challenges. There were issues that maybe we take for granted, and we just do not understand how much and how many people worked to achieve the standard that we have today. And this is thank you, Your Honor, to you and to your colleagues for working so hard on achieving that. And we hope that with the new generation, that standard will be improved, and we'll strive to really achieve, I think what Vice Rector said, the overcoming those challenges that we have in rules-based system that today, and architecture that today have been, the cracks have been visible for quite some time. I will not take much time. I just would like to open the floor for any questions, if anyone has. Please, just raise your hand, unless, and yes, please, I think we have.
Okay, I have one. First of all, I want to thank you for your time, and I think we all appreciate this. And I actually have two questions. So first question touches upon the length of the proceedings before the ICC, and I think some of us might have heard the case of Laurent Gbagbo, the former head of state of Ivory Coast, and his proceedings that have been taking place for, I think, over 10 years before the decision of the acquittal was issued. I want to know, what is the reason why the proceedings take so long? So what is the most time-consuming part of the proceedings? Is it gathering the evidence, or gathering the statement of witnesses, or is it establishing the line of argumentation? And second question touches upon the complementary principle. Is it the discretion of a country, and how does ICC actually assess the unwillingness and unable principle? And has there ever been an implementation or development of that principle lately before the ICC? So, thank you.
I think it's a real mixture of things, but the first is that length, it doesn't always mean the actual trial itself. It's the gaps. Gbagbo and Blegodet, which I had something to do with, in fact, because I was one of the judges who dealt with the application by Mr. Blegodet for compensation for the time that he'd been held. And he wanted, I think it was something like 800,000 euros for being locked up for 6 years and then being acquitted. I wasn't aware it was quite as long as that, actually. But as I say, going back to it, it's first of all, from the time they surrender, depending on how old the case is, the prosecution usually asks for time to go back and bring it up to date. Most surrenders happen without much warning, or so there's a gap there. There's then the confirmation proceedings, which shouldn't take very long, but can do. There's a case at the moment, which is that of Mr. Mockham, where because there's been trouble with his lawyers, one of his lawyers was disqualified and so on, he surrendered about 9 months ago. The hearing's only just been held and the decision isn't due until about December. And then you get the problem about too many cases for the courtrooms that we have available, which has been unusual but is still continuing. It's usually that for example, a witness that is due to appear, he can't appear for one reason or another. So the court then adjourns until another witness can be found. And it's not like having domestic cases where you can just go to the next town orders and bring the witness in. You can't. So there are any number of reasons, but I don't believe that that sort of length that you're talking about would happen these days anymore. I don't know enough about the case, as I say, to opine, but it did take a very, very long time indeed. And we now have one of the many reforms that have been instituted is that judgment on a trial has to be issued within 6 months, as opposed to, I think in Blago Day, it took much, much longer. I can't remember how long it took, so that's one of the reasons. But I think, and this is a view taken by those of us who are trial judges, there are many procedures which we are now trying to institute as standard ones across the board, which can shorten trials, and certainly agreed facts which are not in dispute. You have to persuade the defense sometimes, particularly those who are American trained, where the rule is you don't agree anything. The prosecution has brought this case against your client. They have to prove that you, the defense, are not going to agree anything. Well, that is being eroded because trials are not a game. Complementarity. Effectively, it's for the state to show that on what I call the balance of probabilities, which is a common law aspect, as I discovered. I thought it was standard, but it means they have to show that they have in fact acted properly and complied with the test, that they were willing and they tried to do it. I'm trying to think of whether there's been a recent case where I think Colombia, I think one of the reasons was that it was decided that Colombia was actually now properly willing and able to prosecute. But I'm trying to think whether there was another case quite more recently. But the onus certainly is on the state to show that.
Anyone else would like to?
Hello. First of all, thank you very much for the very valuable information. And I would like to ask you about the efficiency you've talked about during this public lecture. In particular, how ICC approaches the issue of cooperation with member states and the arresting persons against which arrest warrants are issued and brought to the courts. Thank you.
Yeah, this really is something which is a question which is better addressed to somebody from the registry or the prosecution. Various attempts are made to persuade countries that where those for who arrest warrants have been issued to hand them over. As I'm going to be talking about tomorrow, I mean, Omar Bashir, when he was still roaming around the place, went to a half a dozen different countries. I mean, nearly all the cases revolve about him, and nobody handed him over. Part of the argument that countries have is that they would be in breach, they say, of their international law obligations. It is a really interesting topic, this, and I was glad when I was asked to speak about it, because it forced me to do quite a lot of research as well. But effectively, it's not the argument that they should not be handed over is one which the ICC has tried to lay to rest, but at the moment hasn't in the Jordan case. But it doesn't make much difference. I suppose what needs to happen, and this really has to be done, I think, by the prosecuting the registry, is for strong diplomatic pressures to be brought on countries where these people are, that they must comply, particularly when it's states parties. If they're not states parties, there's not much you can do. But if it's a states party, which all these countries have been, then it really ought to be complying with its obligations. As far as I know, one of the suggestions that's being made is that cases where the warrants have been outstanding for a number of years are going to be as it were, brought to the forefront of the public's mind by being republicized on the website and so on and so forth. But other than that, it really has to be a question of diplomatic pressure, I think. And that I may say is one of the great drawbacks of the ICC, that it doesn't have the effective force that ICTY certainly had.
Anyone else?
Is that the same? Hi, thank you for this very interesting lecture, taking us through the history and legal aspects of international criminal justice. And my question is this the same regarding the ongoing investigations when the countries are not cooperating? Is that the instrument that ICC holds only the diplomatic one? Or they also have some actual instruments they can take into action?
Yes. Is there any other action they can take other than diplomatic? Is that what you're asking?
Yeah. What are the other instruments that they can take into action while the country is not cooperating during conducting the investigation?
It depends. If the investigation is launched, not with at the behest of the country, for example, the investigation into the Côte d'Ivoire happened because the Côte d'Ivoire itself referred the whole matter to the ICC, said we can't investigate what happened, we want you to investigate. But if the investigation, for example, is a Security Council referral, as Sudan was, Sudan doesn't want anything to do with this investigation. It certainly didn't want to investigate Bashir. There was, or any of his henchmen. The reason that Al-Rahman is before the court is because in 2017, Bashir was overthrown, a government was elected, and they were very keen on prosecuting those who they believed were responsible for the events of 2003 to 4. And Al-Rahman surrendered himself, rather, I feel, because Sudan has the death penalty, and he didn't want to face trial in Sudan rather than the ICC. And then, of course, but then the democratic government was overthrown by the generals, and so we were back to square one. It was rather difficult. And basically speaking, for other, I'm trying to think, Myanmar, as I say, absolutely no cooperation. They're certainly not going to cooperate. Any of the other countries, Venezuela, to a certain extent, is cooperating. The Philippines are not exactly cooperating, but they're not trying to prevent investigation going on. It's really a question of, I think it's a question of what government is in power. But investigators, if you look at Myanmar, for example, it's being investigated not just by the ICC, but also by the UN organization, the international something or other mechanism for Myanmar, investigative mechanism for Myanmar, and they're not doing much better. And in fact, there are investigators falling over each other, but without much success. As you know, so far, there have been no indictments issued at all. Not a very useful answer, I know, but the best I can do.
No, thank you.
I would like to pose one question from on my behalf, and without going into what you asked us not to cover, but still somewhere very close. But the question is, you as a judge, but you're as a professional in international criminal law. My question is the following: the ICC has quite a difficult relations with at least 3 permanent Security Council permanent members. Because of that, you underscored about the impossibility of referring the situation of Syria to the court. At the same time, at the beginning of your lecture today, you talked about, you quoted something that fell into my heart, that the law shall not stop with punishment of petty crimes. So, and with the development of what we see, or the ideas of how the international criminal law could develop, is that we see the possibility of, when ICC cannot address some situations, alternative way of ideas of having hybrid or internationalized tribunals. So my question is not about that. My question is about the fragmentation. Do you see the risk of having, because you talked about the issue of inconsistency of approaches even within one court, right? So if there is the fragmentation of international criminal law, what could be the risks, overall risks in relation to those standards that you underscored as the legacy and as the success of international criminal law?
Okay, I'm sure everybody understands why I have to be really cautious about this. I think it's important, and it's one of the important aspects of having a single court, if at all possible, to deal with all international crimes, those that are not being dealt with domestically, is that it creates, as you rightly put it, standards. It creates jurisprudence, which at the moment, justifiably, there's been criticism of inconsistent decisions. But my view is very much that we've taken that on board, and there's going to be a much greater, sorry, I'm trying to think of the right word, greater attention paid to not departing from established jurisprudence unless there is a really good reason, or it hasn't actually, is an issue that hasn't come up before. And I think equally that if you have a number of different courts dealing with the same situation, without one court having primacy, or without one court being the one that everybody looks at, you are likely to create wholly inconsistent decisions. You are likely to have a duplication of effort, a duplication of trials dealing with the same incident, which means that witnesses in particular, and this has always been one of the great problems, having to testify and retestify about that incident, or incidents. But above all, international justice comes expensive. I mean, you only have to look at the astounding figures of what was spent on IC2I alone. Who is money that is spent on one institution deprives another of it, if you see what I mean. And I think it's very difficult, as I say, in times of economic difficulty, to persuade people to fund international institutions, and the idea that there should be more created. It's not an attractive one, but I think the main reason is it is bound to cause inconsistent decisions and a duplication of effort.